Hi, everyone. I'm here with Frank Ravitch, and we are going to talk about our casebook, Law and Religion, Cases and Materials.
Materials,
Yeah, it
yes.
used to be Cases, Commentary, and Materials. We are delighted to introduce the fourth edition. And what we were going to do over the course of the next few minutes is introduce the book, our approach, how students and perhaps faculty ought to think about it if you've got an interest either in teaching or in learning law and religion, primarily from a US, but with a comparative aspect as well. So Frank, why don't we start? Tell us, you were solo editions 1 and 2, and that's the big bedrock of the book. Tell me what brought you to the book. What was your approach? What your objectives were?
You know, it's interesting. When I had been teaching law and religion for a little while when I designed the first edition of the book, and you know, really there were just a few factors. One, there were some amazing books out there, right? And most of them did try to be, I guess you could say, as balanced as possible, but there were certain things that tended to come through in terms of perspectives on different issues that may have bent one way or the other. And the goal of this book was to really take it down the middle and really design a book that will allow faculty to use it how they want to, and students to answer a lot of, learn about a lot of materials and answer a lot of their own questions without feeling that the material's pushing them one way or the other, so that they get the full perspective and can make their own decisions. The other thing that in the first couple editions of the book that were key, you know, what I didn't want to do was over edit cases. I found that a lot of the context, law and religion is an area where factual context, disagreements between concurring and dissenting justices and majority justices, it's really, really important. So I did obviously a ton of editing, but there was a conscientious effort not to over edit, so that students using the book and faculty using the book could get the full context for the case and the debates going on between the justices that sometimes led to changes in the law later. And then finally, you know, we changed it a bit for this edition because there's so much new law and new material since that first and second edition. But I wanted to have readings in the book because I felt that there really wasn't enough of that in case books. With that said, as so much more material has evolved over the last 10, 15 years, that space might have been better spent on some other things. And so we've used additions to the notes and to the narrative material to cover that. And I said finally, but one finally is there really was very little discussion of religious law in case books at that time. And I felt that while the law and religion, the constitutional and RFRA and things like that is very, very important, I wanted to be sure to have discussion of religious legal systems, even if it's sort of a tapas, because I felt that was very important. So that was the basis. That's where this book came from. And I was so happy to bring you in on the third edition and now the fourth edition, because you add this beautiful, amazing comparative law perspective that is so important.
Right, and I do want to emphasize and one of the things that extraordinarily attractive to me as well were two things. One you've mentioned, and the other I'm going to mention now as well. The neutrality is critically important. Religion can be ideological and heavily ideologically focused, which I think makes it difficult for students and faculty to express their own voices, their own way, which I think is very important. And one of the things that I find in the way I teach the materials as well is to speak about plausibility in legal analysis, plausibility in outcome, and then go underneath that plausibility to look at the principles, outlooks, perspectives that may guide the range of plausibility, and then invite students as they wrestle with the opinion to look into themselves, their own values, their own views, to be open to those of others, so that by the time they're done with the course, they can feel invested in the materials, not because they've received it from someone else, but because they've now been able to open themselves to it and to grow with their learning from the material. So that was critically important. And then the second thing, which goes, you sort of mentioned, but I want to really clarify here for me, was that the one of the things that I tend to not like very much, especially when we're dealing with complex principles-based jurisprudence like law and religion, is materials that tend to want to fill in the entire universe, right? Every aspect of law and religion has 10,000 cases, and we're going to go through them all. Students wind up, and faculty as well, wind up being, you lose your breath. And so painting the bigger picture, learning the deductive as well as the range of analytical approaches makes it that much easier than, for example, and what I do is a lot of hypotheticals that then touch on all of these, all of the other possibilities, to work through them, invite my students to explore it, and then we discuss it. But the book is, in a sense, clean in that it's a nice tool shed where you become proficient in learning the basics of managing these tools, so that anything that comes at you, then you are equipped to work through. And so for me, that was fabulous. And then adding,
and that's a great part about it, is that professors have the book gives them the ability to stress what tools they want to stress, but also if they want to approach it and just have the kit to address everything that may come at them from students, this book gives that to them without pushing them in a direction.
Right. And then the thing I add is, when and this has always been, it's a problem everywhere, but one tends to center one's own jurisprudence. And sometimes if you center it too much, especially when you're dealing with religion, which is global, which is ancient, which is, their permutations and combinations can sometimes make the jurisprudence, I think, a little too detached. So what my section does is to try to bring you back to get the students and the faculty members as well to lift their gaze up just a little bit, so that they can say, aha, this is a glorious experiment in jurisprudence, in a glorious experiment in our republic for a very different model of the relationship of the state and society and religion together within a singular polity. But how do you understand that singularity? It's difficult to do that without seeing the other approaches that exist all over the world. And I start, and of course it's impossible to teach global jurisprudence of law and religion. And so my especially for faculty who are, and students who are not conversant in a lot of areas, is to offer you one of three choices. You can either take an issue. In my case, we're looking at the comparative approaches by the regulation of religious headgear, right? The hijab, the niqab, and those things. And that would be enough from there to do the comparative. Or you can look at it from the perspective of international legal frameworks, or you can look at it from the increasingly rich jurisprudence of regional human rights organizations, and primarily the European Court of Human Rights, as well as the Inter-American Court of Human Rights. And with that option, you then develop a kind of richness. But again, taking as its cue what Frank had pioneered in the first and second editions with respect to the approach of the materials and the engagement of faculty and students.
Yeah, and I think that's key because at this point in time, what we're seeing, some of the things that you can learn looking at other legal systems about our own system. I'm working on a book now, not a case book, where that's exactly what it's doing. It's looking at the ECHR system, the Japanese system, the Vietnamese system, and the US system, and looking at how, and what I found is I've learned a lot more about the US system in some ways by looking at the other system. When you look at the ECHR manifestation of religion and the limitations on manifestations of religion, well, how does that really, isn't that a lot about what we're looking at when we look at, exemption questions in the US, the right to practice religion versus the right to belief? There's overlap there. Same thing in the Japanese Shukyo Hojinho, Religious Juridical Persons Act. And so, yeah, I think that's a very valuable, it's why it's so good to have that perspective, because you learn more about looking at other perspectives allows you to learn more about your own. And of course, the book sets your ability up to really know the US system very, very well by the time you get to the comparative system, so that you'll have a mirror on something that you understand rather than a mirror on something that you're extremely confused about.
So if you were going to give students and faculty advice on how to approach the materials, what kind of advice would you give them?
I would say the book is designed around contextual issues. And so when you approach the book, you're not going from 1787 to 2021 or whatever year. You're looking at issues like school prayer, religious symbolism in public spaces, equal access, free exercise of religion, whether, in the context of exemptions under things like RFRA or under the older constitutional system. And you're going right up. We have cases in the fourth edition that were just decided a couple of months ago from the time we're doing this video. And so, remember to look at this conceptually, that there are different tests and there are different approaches. But if you look at it, if you look at the context of what's going on, school context versus legislative context, right? Public forum context versus non-public forum context, general aid context versus, other sorts of aid contexts. And the book gives you all that information. The key is, if you look at it contextually, I think you're going to have a much richer ability to understand the law and even the history of the law than it would be if you look at it chronologically. I want to know what happened in 1787 to 2021, but it's not a linear pattern. There are valleys and mountains and things change, but they go back and stay the same, and then they change again. So I think looking at this conceptually and contextually that would be my way of viewing it. Look, if you're a student outlining or a faculty member grappling with these issues, I think, again, looking at them contextually, which is how the book presents them, I think is very, very helpful. And again, as you look at the context, the concepts come out. So you also get theoretical concepts and you get practical concepts. And so that's my advice: conceptual and contextual.
Right. And let me add to that, because our approaches will be different, and which is what makes this great. There is no one way to do this. So I will do context and I will do that. But I tend to emphasize two things that are related, but slightly different. One is themes, and the other is intersections. So, and you wind up in the same place. So themes, neutrality, themes, accommodation, themes, walls. And I will take those themes and then apply them to context. Does the theme apply mindlessly? Does context alter the theme? And then I add to that intersectionality. What else is going on? So I approach context through the back door. You go right through the front.
But
But I
ironically, I use that front door to go right where you're going through the back door. So I use context as a way for my, accommodationism,
right.
separationism, non-foundationalism, all of these things can kind of come, as you go from context to context, you see these concepts, you see these theoretical background principles evolving and changing and adapting. And same thing with intersectionality as well. So yeah, I think we enter through different entrances, but we walk through the same house in a way.
Exactly. And for faculty and students, the advice then is don't worry about the way in which you approach it. The area is rich enough. You're going to get to where we hope that you get to, but there's no one and only or singular best way of doing it. So play with the materials, think about how you approach this, and then just get into the richness of the materials in any one of these possible ways. And I think that will really take you through the two big areas. And of course, we separate them out. I spend a lot of time worrying about, and we have to do this, of course, for pedagogical reasons, but then trying to put them back together, right? So we have establishment and we have free exercise, right? There's a temptation, and I've seen there are battles. Should we do free exercise first, or should we do establishment first? And if we do one, it overlaps with the other. Any advice?
Yeah, the book's designed to do establishment first, because through doing that, you start seeing the evolution of, or at least recognition of, religious pluralism in the US, which is so central to free exercise as well. But it's funny, I thought about that when I designed the book initially. And so theoretically, in the way this book is structured, you could do the free exercise, what's now chapter 5, first, and then do the establishment material. But my sense is that what establishment does, because it touches on so many things, is it gives you a sense for religious diversity and how it interacts with government in different ways. And then when you get to free exercise, it's already second nature for you. And so you're confronting very different issues in some ways there. But yet you really are well equipped to understand the fact that we're dealing with a very religiously pluralistic society interacting with government, because you see a lot of that in the Establishment Clause battles, where frequently plaintiffs are religious minorities who are being having sort of religion forced on them potentially, or by government entities, or perhaps not. But then we see in the free exercise context that pluralism play out. And then I do think also the big section that deals with ecclesiastical abstention and church autonomy, that issue, I think without having some background in free exercise and establishment, the way that issue has evolved over time, it would be harder to really understand some of the court's decisions on things like the ministerial exception, if you didn't have already the background in establishment and free exercise. So I think that having that order, first establishment, then free exercise, then sort of the doctrines of church autonomy and ecclesiastical abstention, makes the most sense. But with that said, there's nothing magical about that order. It's simply, I think the most efficient way to present it with your students building their knowledge of the society in which all of this is functioning and some of the tensions in that society. So, but if someone chose to do free exercise first, then a stop, there's no problem there. The book allows you to do that, which is the beauty to it. Yeah.
Now, I approach it slightly differently in terms of the conception. I also agree I will do establishment first and then free exercise. But the reason I find that very useful is that for me, establishment is institutional law and institutional lawmaking. So it's the law of collectives. And as you mentioned, it becomes critically important with the ecclesiastical exception. So you start with the institutions of religion. Free exercise is the individual. So we go from the institution, the aggregations, the churches, the practice, to the individual as he or she wrestles with her notion of divinity or its absence or its manifestation. And then the interaction between the two is the stuff that then is possible when you go from institution to individual. And then that works just seamlessly to highlight the particular problems when you move outside of the United States of dealing with what becomes a very, very difficult issue, which is this tension in the borderlands between the individual and the institution, especially in states, unlike the United States, that may be theocratic or that may be positively secular in their constitutional order. So for me, that's the reason it works as well. So you could, if you like, as you teach this, view this as the religious law of institutions, the religious law of individuals, their interaction with the state and society, and then the conversation of that with the with developments outside of the U.S. But either way, but again, you can do it the reverse too. I like you, Frank. I much prefer to do it in this way. All right, so I know that we're running out of time, and I want to give you opportunity. Any last thoughts, expressions, advice?
One couple of quick things. I think there's a really fun exercise. We mention it in the teacher's manual, but I think it's a really good thought exercise to do with your students. Is sort of pretend that the U.S. has been essentially part of, we didn't have the Revolutionary War. We're still part of England. We, in 2020 or 21 or whatever year you're teaching, we break off from England. We have the same demographics that we have today. We have the same sort of history of case law and statutes, but it's not binding anymore. It was the Privy Council or something like that. And so now you have to craft religion clauses, but you have to do so in a way that can get 2/3 of your students are both the House and the Senate, so to speak. So you've got to craft them in such a way that you can get a 2/3 vote to pass whatever you come up with. And it's both a helpful exercise because it helps you grapple with all the things you now know. I do this usually after we've covered establishment and free exercise, at least, if not ecclesiastical abstention also. And it forces you to grapple with all of these different principles and concepts and see, is this the only way to do it? But then also realize what the actual framers were dealing with, which is, you got to get 2/3 of the people to agree on what you're coming up with. So there may be a need for compromise. And the end result, by the way, if people don't, get the 2/3, is there's no religion clauses. And then the question is, well, what does that mean if that happens? And so I think that's a really helpful drill. It sort of creates a microcosm. In terms of general advice, because you can take or leave that drill, my advice to both faculty and students, and this might seem, so obvious, but enjoy it. Law and religion is a powerfully rich area. And if we come at it from a dialogic perspective, where we're sort of teaching it and not preaching. In other words, we're letting our students make up their minds by presenting lots of different perspectives and lots of different views, or leaving that the material allows you to have that, leave it open. I just think it is such a rich experience. I learn I've been doing this for a long, long time. You can tell from my hairline, and in terms of teaching law and religion, it's one of the first courses I ever taught, and I still my favorite course. Torts is a close second, but law and religion still my favorite. And I will say, really enjoy it. I learn from my students from perspectives every semester. And of course, the hope is they're learning from me as well. And just, I think for faculty too, just enjoy the thrill of teaching this very controversial, cutting edge, and fascinating material.
And the only thing, and I absolutely agree, the only thing I will add for advice is Law and Religion is an excellent course for lawyers and policymakers to learn empathy, that it is impossible to work through the constitutional developments of law and religion without learning to get outside of yourself and looking at or getting as close as you can into the shoes of your opponents. And that in a sense, the brilliance of our ability to craft this in what could otherwise be an extraordinarily contentious and divisive area, and it is to some extent, but not so much that the polity has ripped itself to shreds, is the ability for people to avoid demonization of the other, however different they may be, whether politically, socially, or religiously, as these things manifest. And in a sense, bringing that into law and religion, I think will profoundly expand your ability to work through a complex jurisprudence in ways that will make you a better lawyer, not just a constitutional lawyer, but a better lawyer all around.
Yeah, I think that's absolutely true. I wish every student could see how the vast majority of law and religion scholars, we deal with each other. We all have vast array of opinions, and there are significant disagreements. And yet there is this empathy and this respect that I have for my colleagues, whether I agree or disagree with them, and that they have hopefully for me as well, and we all have for each other. It's not everybody, but the vast majority are so open to learning from each other, and agreement and disagreement makes the debates richer. Exactly. But I think it would be good for students to sort of see how law and religion scholars really do interact with each other. We really do exactly what Larry said. We engage with each other in a respectful, for the most part, in a respectful and caring way, with a great deal of empathy. And that's something that is sadly lacking sometimes in modern society. So if, coming through law and religion with that, it's one of the most controversial areas. If you're able to come through law and religion with that, you're going to be a better lawyer, because as Larry said, you're going to be able to do it without underestimating your opponent. The best lawyers, take their opponents seriously and understand the weaknesses in their own arguments and the strengths in their opponent's arguments.
Right, and always remembering that at the end of the day, you will still have to live with each other.
Yeah. And in this field in particular, out in litigation, you're going to see the same people over and over again at SCOTUS or wherever.
You're going to see your neighbors. You're going to see now I'm going to be naughty. You're going to see your cake baker. You're going to see your notion store operator. You're going to see your hospital. You're going to live with them in your community all the time. So I think we'll have, and I know that you guys will have great discussions, all you folks. It's going to be great. And we hope that you all enjoy the materials, and we look forward to engaging with you, and looking forward to hearing from you about your experiences both with the book and with the field. As
Yeah,
you,
our email is always open, for people adopting and using the book.
yeah. So thank you again, Frank. Thank you, folks, for listening, and stay tuned. We'll be doing more discussions about key cases in law and religion.
Yep, I think next up will be Levy Weissman and Santa Fe v. Doe.
Absolutely. All right. Take care.
Take care.